I'm finished on Zoom. No, I'm not taking any.
Do you really?
I'm finishing what I still have, but no, I'm not taking. She
What
has
is
her
it
own.
saying?
I'm done. I still have 5 minutes to go. Oh, 6:05.
Was it set up and it's going?
Yeah, you can start whenever you're ready. No, that was
Are you James C. McLeod?
I'm no better now.
That's a true.
It's there. It's good to be here.
It's nice, I like it.
I was sitting in here all morning.
So you're cool, so. If I could stop blowing my nose today. Allergy.
Mr. Bob, my hero. Yeah.
I do, ma'am. What's up with you? We haven't heard anything yet, have we?
No, she got real quiet. I'll just. She was bullying me.
Yeah. And I think it's, you know, she was doing that thing
I don't.
that they do. The threat is, well, you're gonna cost him their benefits.
Right.
That's wrong.
Well, no, that's why I didn't want to,
Well, we're sensitive to that. We don't want to create that problem. I
yeah.
agree.
So I called him and he said, called me back and said, no, you don't owe me anything.
And I appreciate that, but
I don't have.
he may find from his company. But as I said in the email, I think it's wrong just because of the relocation involved, go back and we was,
No, I agree.
we already have. You can only do what we can do.
No, she's quiet. I'm sure she's.
And I asked her, I said, have your company reviewed.
Yeah, I'm hungry. You're not sure.
Did you bring enough for everybody? No, I'm just saying.
Well, I'll let you have a smell.
I don't want to, what is it?
Pizza? Campesi's.
I don't think it's right, is it?
It's not fried.
I don't get right.
And if it's not right.
It can't be good.
But they have cheese on it.
Well, it could be, but help, as it were. Yes.
So I'm just about eating my lunch. I'm still enjoying it all.
Return and sign in, please.
It's okay.
Sounds before I get my hand.
Say what idea.
What is the IBS? AWIBS website?
Yes.
I'm bored. Right.
Hey, this is one up, right?
What's up with that IPA activity, man?
Yeah, this is one of them right here.
That's it.
You,
Good, how are you?
thank you. Oh, it's gonna be a great class.
I know, right?
You have condominiums going on?
Yeah,
We just closed on one
we just closed on one.
last week. Same place you worked at.
Oh, really?
Yeah.
Oh, that's cool.
I don't know, it's from the.
See, they're around.
Yeah.
Yeah, we can see.
I know.
That's the
I know.
first.
See my car. Oh, I could just, well, my, I get allergies, but I'm about to go to this. You're never seen private guy, I can't seem to.
Sure, signing get documents back here. But you'll get a check later.
Yeah.
I know, right, I forgot.
So.
No, it was last, had a real big
Oh.
headshot.
Well, at least made it.
Please, good, good, good.
Last week.
Make sure, and when you sign in, probably put somebody else's name there too, so it looks like we had a big crowd. Because you know, we get credit for bigger numbers.
I mean,
Yeah,
Yeah.
I tell people find another one. I know. Yeah, yeah. Oh, good, good. Who's your company? Did you say you want to?
Be sure and sign in the back and get the paperwork back. Hello, how are you doing? Thanks for being here.
That's what I said. How are you? That's good to know. Do you have one?
You sat here, seat on the front row.
Well, that's not supposed to happen.
Yeah, he wanted to take it off.
And lost. How do you lose to them? Of course, how does Notre Dame lose to Marshall? Whoa.
I said, George.
Everybody want to talk about finance? What was that? Who?
Yeah, I mean.
The whole time.
Oh, yeah. I hear that, here they cheated. Striking the goal kicker or something. You want to talk? Okay, while we're waiting on our first speaker to come up, let's talk a little bit about what we're kind of looking at doing today. And while we're focused somewhat on condos, the condo transaction, reality is these three aspects are involved in every transaction. We're going to look at from the lender standpoint. We're going to have an attorney come in, Scott Rucker, who many of you know, attorney with Republic Title. He's going to come in about 2 o'clock and talk about the title company side of all this, and then I'm going to talk about the contract side of it. So you have that in every transaction you do. You know, those things for aspects. We're just going to look at it from this standpoint. And the first thing we want to do. Thank you, Debbie. Have we got enough folder? We got enough materials back here?
Yeah.
We're good. Is looking at it from the lender standpoint. In every transaction you do, if you have the buyer, one of the first things you do is look at the financing for your buyer. And they say, well, we're going to pay cash. Say, good. Where is it? Right now, today. Oh, no. Well, it's in the bank. Is it in a bank here in this country today? No, it's Dubai. Oh, okay. So what are their rules for transferring money out of there? You know, so you want to know where it is. However they're going to get the money to pay for it. You want to know. So the buyer, because as you know, working with buyers is very labor intensive. If you've got a seller, you would want to know all the aspects of your seller's property being bought, either cash or financing. Because there's some properties that are not eligible for all financing. For example, and you can correct me on some of this if I say some things that are just totally my opinion. But one of the things that I think with Fannie Mae and Freddie Mac is they like mainstream properties.
Yep.
We had an agent with a property, a listing down in East Dallas. And the foundation was Bodart blocks. That was how it was built back then. Fannie Mae said, no, sorry, not interested. It's not a good mainstream property. So we're just not interested. So, you know, anytime you've got a property, you say, you know, what does it qualify for? Is this a nice mainstream property, Fannie Mae, Freddie Mac, FHA, VA, what is it for? So you're always going to look at that. We have condominiums, you have special situations. Because, you know, your buyer is buying a cube of air and your seller is selling a cube of air. And there are all kinds of things that surround it. So the first thing we're going to do is like Colton talked to us about how a lender looks at a condominium transaction. What are some of the issues and the challenges that they have? And look at our fine Zoom folks up there. We got some Zoom and they're almost all awake. It's good. Colton, please come. He's with Fairway. He's just right around the corner here.
Awesome.
And You need anything else from us? So let's give him. Welcome. All these good deals.
Howdy.
Howdy.
So howdy.
Howdy.
There we go. I know we lost this week, but it's okay. We still drink the Kool-Aid at A&M. With that, thank y'all so much for having me. Appreciate Bob coming by last week and inviting me to come talk today to the condo class. Condos are super, super important in our world. And for me, I go from being just a bricklayer to a surgeon sometimes with condos. So with that, there's a lot of things that you can do on the realtor side up front to avoid any roadblocks, as well as be able to identify things within condos that could affect the transaction as a whole. The last thing you want to do is spend all your time showing all these wonderful condos, go to the lender and you go, oh, we can't even finance this, right? So there's a handful of different things that we need to look at first and foremost before we even typically go show a property. So I'm going to talk about what condos are eligible and non-eligible first, and it all depends on product type. So for an FHA or a VA buyer, they have to be approved on the HUD condo approval list. So you can look up HUD, HUD, condo approval list, and you'll be able to see if it is FHA or VA approved. If it is,
For the structure,
yes,
still,
yes.
Yes.
Correct. And if it is not approved, that does not mean that the roadblock ends there. Although 99% of the time it typically does, just due to a time constraint. What I mean by that is, believe it or not, we can actually still request for a complex to get FHA approved or VA approved. The earliest that can happen is typically around 30 days, which we have requested twice in the past. We have gotten one to go through, the other one did not. And the one that did go through, it was 6 months after the person already bought, but it was good for the future buyers. The next is going to be for conventional, right? The most typical. For conventional, there are two different, kind of breaks off into two separate categories, warrantable and non-warrantable. And for non-warrantables, there are financing options. They are typically, lack of better terms, atrocious. Just because we need to stay on the warrantable side. Now, the warrantable side is determined based on a condo questionnaire. So the first thing that we're going to do when y'all go under contract with a buyer is we are going to order what's called a condo questionnaire. This condo questionnaire is going to tell us everything about the complex itself, the HOA, the funding and the reserves within the HOA, and the plans moving forward with the condo. So if your buyer is putting 10% down or more, awesome, you get what's called a limited review. So now we're just going to be looking at a handful of things. We're not even going to look at the budget, which is typically most of the ugly stuff on a condo. If we're putting less than 10% down, then we will have a full review. And that is where we analyze everything, including the master HOA policy and where they're currently at with their funds. Does anybody have any questions around just those two breakdowns of conventional, warrantable, and non-warrantable?
Is that the same thing as the condo, what's the word I was looking for now? It's that's, tell me guys.
Condo docs.
Thanks. Okay, is that the same thing? And should we as agents read that?
So when you say the condo docs,
Yeah, the
Documents referred to in paragraph 2 of the condo contract. Yeah, so what you're, in the question or what you're looking for, depending on what the situation is all the condominium docs, including the bylaws, all the covenants, all of those. You looking at all of that?
yes.
Okay, now define warrantable and not warrantable.
Gotcha.
What is it when you look at this and you see this on it? That means you won't warrant it. What does that mean when you say you won't warrant it? You won't insure that loan, you won't make that loan, you won't be able to sell that loan to Fannie Mae, Freddie Mac.
Correct. So
Clarify what that means.
absolutely. So full transparency, Fairway, and plug ourselves here. We have an entire condo desk. So while most people have to get everything ready to go and then it gets to the underwriter and they go, I have an entire condo desk who does get to do some of this reviewing for me. So I can't take all the credit. But the biggest difference between a warrantable and a non-warrantable is we take a look at, is this something that Fannie Mae and Freddie Mac would insure? Is this something that they would put their stamp of approval on? If they will not, then typically there's reasons that we should also avoid that. A handful of different reasons. I mean, there's, depending on the age of the property, depending on if there are reserves on this property, there are certain condominiums that look absolutely stunning and the advertising is great. You look at the funds and there is no money left. There is not nearly enough. Another thing that I've seen recently, and this is for my people that are looking at Dallas condos, I've seen a lot of these complexes go from long-term rentals to now they're starting to sell them off. The problem is that a lot of these HOAs don't have nearly enough sold. They have to have a certain amount sold within that complex for them to become warrantable. So that's another thing to look at. But here's the easiest way to kind of take a step back and look at it from 10,000 feet. Let's look at the comps and let's see if there were conventional loans in the past. If there were conventional loans in the past, then you could take a solid assumption and say, this is probably going to be able to be a warrantable condo. Does that make sense? Awesome. That's the things I want to go over. Also, you can even simply ask the listing agent if it's warrantable. Typically, they'll know this information. You would hope they know this information. If not, then again, you want to start looking at those comps in the past to see if anything has been pushed through. Now, another thing is with that approval list, taking a step back to the FHA and VA that I talked about, remember, we can go on the HUD, we can see if that complex is FHA or VA approved. We need to look at the date. We need to see when that was approved. If that thing was approved 5 years ago, it might not be approved now. So we need to be looking within.
Why would it change?
Well, because just like Texas
Reserves or something, or?
well, just like Texas weather, everything can change with the condo in 5 years. Not only with the budgeting, but also the plans that they did have that did not go through, things that have changed that now need to be fixed, for example.
Okay.
They could have actually taken some of this condo and turned it into long-term rentals. These could have been investors that came in and bought this stuff. I mean, I've seen it pretty
We're
much.
talking the reverse of taking apartments and converting them to condos.
Mhm.
You're talking about taking.
I'm saying what
condos and
can
converting
happen.
some of them to apartments.
I'm saying what could happen in 5 years.
Okay.
Yes, sir.
So what's the timeline for, when you say, okay, it's been this long, so we need to take a harder look at it?
2 years.
Okay.
Over 2 years, if the approval for that FHA or VA is over 2 years, I would take a second look at it. Awesome.
Ask you a question.
Yes, ma'am.
If you have a condo that's maybe not VA or FHA approved yet, and you had mentioned like you had a client who did that 6 months after purchasing. Is it the lender who changes that status, or how does that?
So we don't change the status, but essentially we basically put together a full case and send it off to the Federal Housing Administration or the Veteran Affairs and give them basically this proposal.
Okay,
They'll come in and do their entire full review, and then they'll come back to us and let us know. We can get it approved if X, Y, and Z, or it's approved or it's denied. So those are the 3 different ways we could hear back. Yes, sir.
Does that require the HOA's approval and involvement? How would you say?
100%. Absolutely. We definitely need the HOA's involvement. If you want to be a rock star realtor in condos, over communicate with the HOA with condos. Every single time I hop on a call with a borrower and we're about to get a contract and they ask me, Colton, is date October 3rd comfortable for you? Is that something that you and your team can get done by then? Yes, however, I have worked with HOAs who have dragged their feet. There's somewhere you can't get a phone number for them. And so the best thing that I would do is if you have a client that is looking to even put in an offer, I would make that first call to the HOA and make sure a couple of things. One, you have the right contacts. I've seen us go under contract and that's just start knocking on doors because we didn't know how to find them. And then get in contact with that HOA and see where they're at in their process, see what their previous sales look like. But the biggest thing is just picking up the phone and having that conversation. And once we do go under contract, remember I said I'm going to order that questionnaire and that's going to let us know where we stand with this condo. Sometimes that can take, I've seen it come back in 30 minutes, which it's a very quick document typically. But I've also seen it come back weeks or weeks after. So being in communication with the HOA is absolutely paramount to keep from a loan taking forever to close, just because, you know, they might have 2 people for this giant apartment complex, whatever the case may be.
So this sounds like the homework for the listing agent to make sure that they've had that communication with the HOA and that they understand where they are if they're going to try to get it approved or whatever. They're the ones who are going to do that. So buyers come along and the listing agent one already has all this information. Right? They're the ones that are going to be doing all this.
So to make sure I'm hearing your question right,
All the approvals, all the things that we have to work through for FHA and VA or whatever for the condo association to do. It's when you take a listing, you're going to be right on top of making sure what eligibility your property has.
100%. If you don't, then you have 30,000 blind spots potentially on the other side. It's not like a single family house where we can look at it and know what's going on. This is a completely different animal as a whole. I've seen things that look phenomenal on paper, and we got to underwriting and it just completely fell apart. And so with that, as a listing agent, it's super important to be able to know if I am to, take on buyers and help this person decide on which one, I should at least know what's possible and what's not. And so should they, because you don't want to get under contract and then sure enough, something happens. And if the market continues to go in the position that it was, well, they really wish they would have closed back here. I mean, it's really, really important to stay on top of it when it comes to condos. Yes, sir.
Who do you ask to complete the condo question?
Great question. So we actually reach out to the homeowners association ourselves, and we send, my condo desk team. They send it out to them. They'll send it right back. Like I said, 30 minutes. I've seen it all the way as far as 2 weeks. Typically, I like to see it back in 24 hours. And so on top of that, I'm always reaching out to the agent to make sure that we at least have the questionnaire. That is like one of the biggest kind of foundations for the loan.
Is that a standard form or is that every lender have a different questionnaire, I guess?
That's a good question. So my last company, I did not do condos, and now I do condos. I've been doing condos here for a while. So I only know our form. I would have to double check on that for you.
So one of the things that if you're on the listing side and you, at the very beginning, you're going to be talking to the HOA, how that goes, it'll be really important to you. Because if it's a struggle right now, it's probably not going to get better. It's going to be a red flag for you. You have to decide, do I really want to take this listing? I'm going to have to work a lot harder on this to get their cooperation, particularly in some of the smaller ones where you deal with volunteers, don't have a clue what they're doing anyway. And condominium associations are under a whole different set of rules than the regular metro HOAs are. So you really need to get on board with them right off, find out, how it's going to work out from the listing standpoint. Go ahead.
Yeah. I'd say just one more last thing.
You're not even beginning to be through. We still have questions.
Oh, good.
So good try getting out of here.
So there is a separate contract, obviously, for the condo. What I always request, regardless, if it is a condo contract or if it is a single family residence, while you're writing that contract, take 2 seconds, call your lender, hop on there and make sure everybody's on the same page. So the lender doesn't get a contract that maybe negates some things that actually are possible for the buyer or that are comfortable for the buyer. I think communication with lenders is obviously very important. But again, if you're going to be a rock star agent, not only when you first go under contract, I mean, all the way through closing, reach out to the HOA or to the listing agent, just make sure that everybody's on the same page. Because one thing I have seen, Bob, is that the listing agent doesn't know how slow the HOA is going. So the listing agent's assuming, okay, we got the buyer's approval, we got this, we got what we need, we're going. Oh, wait, the HOA hasn't gotten this to you that you requested 2.5 weeks ago. I could have hopped on a call because I know Macy at front office, whatever that looks like, and I could have got that handled. That was one phone call that could have saved 2 weeks. So as long as the buyer's agent is comfortable with it, I will even sometimes reach out to the listing agent if I'm having issues with the HOA. But first and foremost, being able to see if it's something that's financeable is super important before you go out there and start showing condos.
Okay, so I want you to think about from the buyer's agent standpoint, you've got a buyer and what they're going to be looking at are condominiums. As they're interested in specific units and a specific project, what are the things that the buyer's agent needs to be doing to make sure they don't have these surprises down the road? How are they going to find out? What are they going to do?
Great question. Well, the first thing they need to do is they need to get with the lender and see what kind of product this client is approved for, because that's going to narrow down your search immensely. One, and we're going to be able to see if we're going conventional or potentially, again, FHA or VA. From there, if it's conventional, we can look at the prior comps. We can reach out to the listing agent, or we can reach out to the HOA and see if it's warrantable or non-warrantable. If it's going to be FHA or VA, again, we're going to be looking on the HUD, seeing if those two properties are approved. And then from there, I would even circle back with the lender one last time and say, hey, we're looking at XYZ complex. That complex is warrantable based on me seeing, I saw a conventional close there 3 months ago. Is that something you can take a look at as well? And I'm more than happy to at least have my condo team give it a second look to make sure that property is financeable for that product. So figuring out the product with the lender and then pairing that with the 2 different routes I just told y'all, I think is the best way you can be proactive for a buyer's agent.
From a buyer's agent perspective, questions on that so that you feel comfortable, James?
I just want to share one experience I had, and that is, we looked at HUD and we found like property wasn't approved or the type of loan the buyer needed. Saying, kept reaching out to the lender interpreted the HUD. I mean, I don't know what the difference is, but they were able to look at the HUD documents and determine that building or that community was approved. That's why I think be real careful when you read the HUD information and make sure you evolve.
Now, what HUD information are you talking about, James?
Just whether or not the property is approved for VA or if they take finance.
Is there a HUD list?
Yes.
Okay, so we can go to a HUD list and see where the property is approved and not approved.
Yeah, but you, as a novice in reading, I just interpreted and I didn't think a property would work, but reaching out to the lender.
Was able to determine it was.
There were descriptions of that property by a different name or a different address, a different term. So you just don't want to rely on your own search. You want to involve your lender because you could miss something by reading that.
And just to kind of touch on that, I actually had one not too long ago where essentially this is a 4-building complex and one of the buildings didn't have an updated engineer's report. So we had to request this engineer's report to make sure that this one could actually be financeable. This wasn't even the one that they were living in. But again, that whole complex has to be in the same standing. And so we had to make sure we had that engineer's report for building number 4 so we could finance the condo and building number 1. So that's a great point.
So is insurability fall within that warranty and non-warranty thing, or is that a different category?
Yes, I have sent 2 non-warrantable condo clients to my insurance guy. And it was the first time he didn't call me going, "Hey, Colton, what's up?" Just because I guess they were having issues on the insurance side. When it comes to it, I imagine just full transparency. On non-warrantable condos, the interest rate is going to be substantially higher. Even for a warrantable condo, it's going to be higher than if it was a single family residence home. But when you talk about putting
Okay,
somebody,
now so you're saying when the buyer buys condo, they're gonna pay a higher interest rate?
yes,
Why?
there's a higher risk.
Why is there a higher risk in a condo?
Finally, I'm
You're gonna regret having
27 and
accepted my
0.
invitation.
All right, you snubbed me, Bob.
A class I recently took said they're harder to sell. I don't know if that's true or not.
Do what?
A class I recently took talked about the risk of condos and the higher interest rate, and it said that they're more difficult to sell.
Depends where you are in the cycle,
because
and it is true.
things.
in the cycle. It depends on where you are in the cycle. And there are certain phases of the cycle, the condos are darlings, they're great. And there are others that they're really lagging. So I could see that depending where you are, which phase of the cycle, it could be a higher risk. Yeah.
So you're saying if someone pays cash, because the condo people I'm working with right now, they might not be able to insure it if it's not a non-warranty property.
It's non-warrantable. There is
You
an
might not be able
opportunity
to
that it could not be insured. Yeah,
Hmm.
not saying it's not possible.
That's very helpful.
So we should have had an insurance guy come in.
Just to be clear, we set it a higher risk, just to be clear, you were saying because there might be a lag in the appreciation, so people could be upside down on it.
Could be.
Okay,
Yeah.
But are you talking about insurance like hazard insurance?
correct.
So wouldn't that be the relationship of having all these properties stacked on top of one another, the leak in one is gonna drip through maybe multiple properties underneath? That you wouldn't have in a single family standalone property?
I would imagine my next door neighbor, his house burned down 3 months ago. My house has 2 melted shingles. If the guy next to me's apartment complex burns down, I'm a lot darker than what I am right now.
Janet, did you have the same point?
No, it was about the exact same point of being attached to other units, which you have no control over.
Yeah.
Be it fire, be it water damage, et cetera.
Because we know the risk of people who lives around you. Is it when you're in those tight things like that? I mean, it's a much bigger challenge than my Oklahoma is next to. Yes, ma'am?
Wouldn't that apply to townhomes too then, that are not considered
Good.
condos?
Sure. Yeah.
Does that mean their insurance is more? Because I've sold townhomes. I don't know anybody
Well,
that's ever told me that it was more.
No,
than insurance.
I've actually seen insurance come in a little bit lower on the townhomes.
Townhomes.
I guess the only argument that can be made is you don't have anybody really beneath or above you.
Okay.
That's the time.
Yeah,
That's just me drawing a random argument.
It's truly a townhome.
Yeah,
Yeah, but
It
it's
wouldn't
part of
be.
all condos too.
What?
Isn't there a firewall in condos too?
No.
Yeah, okay.
But if you have row houses and townhomes, you've got party wall agreements. But remember that townhome owner owns the land.
Awesome. Any other questions?
So what's your great advice? 10 words or less to the listing agent when you're going to list a condo. What should immediately be on their to-do list? What should they be? You know, jumping on and say, boy, I gotta make sure I've got this done.
Is this warrantable?
Okay.
Okay, so I'll even give you a cheat code. It's gonna be more than 10 words, so Bob.
Okay. Okay.
So that condo questionnaire is actually accessible for the realtors to buy as well. If it's gonna, they're anywhere between $50 to right around $300. If I'm listing a property, I don't know how much everybody makes. If I'm gonna be making thousands of dollars on this, and I can pay $50 for a condo questionnaire and be able to go and take that and immediately hand it to the buyer's agent. I mean, we need to give an award for that at award meetings. So that would be my advice, being able to see what type of financing is allowed for this property that I'm listing, because that's gonna narrow down the buyers that I accept, of course. Yes, sir.
Just to clarify, when you say that to get a copy of the condo, you get a completed condo questionnaire.
Yes, sir.
Okay.
And there's a charge for that?
Order it from title
Yes.
early.
Hmm?
We order it from title,
We're gonna order it from the HOA.
the HOA, but
Yes.
just order it straight from them instead.
Yes, ma'am.
Okay.
Mhm.
So 10 words or less for the buyer's agent. What do
10 words
they
or-
need to immediately be concerned with?
They need to be immediately concerned with what kind of financing does my buyer qualify for? 2, what kind of financing does this condo apartment complex have? And 3, insurability. I think that some people wait till last minute and they go, wait, was I supposed to do the insurance on my own? We need to make sure that we're getting our people connected with insurance as soon as possible and saying, hey, this is a condo. Can you please take a quick look at this? We might not even need the binder, all that stuff. Let's just take a quick look. So we look at, what is my client's finance ability? What is the property's finance ability? Is it insurable? And lastly, how quick can we get them with Colton so he can make sure they have the best loan ever, right? We're missing that, has 4 steps. So.
Anything else besides all of Bob's questions? We good?
He got me today.
Yeah, well, you know, and as you've been in a few of my classes, you know, I do that. So I always have questions.
I appreciate
Because
it.
I look at it from that perspective. We thank you very much for being here. Anything else? Let's give Colton a hand. Thank you, guys. Everybody have your material because it'll be, I think, Scott, and will be here about 2:00. So let's look at the paperwork we've got. And we want to talk about the contract, the residence condominium contract. What I'd like for us to do is be able to look at it kind of in comparison to the one that you're familiar with, and that's the 1-to-4 family, which is the normal one that you would make use of. We kind of look at some of the changes, some things that we don't normally think about. And some of these things, Scott, the telecom attorney, may actually also address, and that's okay. Unless he disagrees with me, and then it's okay to work it. I always like to operate under advice of counsel, even counsel that doesn't agree with. It's okay. First thing, condominiums are under a different set of the property code than a regular single family homes. Condominium ownership did not even exist in Texas until the 70s. Couldn't own a condominium in Texas because the legal form of ownership didn't exist. One of the things that happened in the 70s and accelerated in the 80s were the trend to apartment conversions. People would take apartment complexes and convert them to condominiums and then sell off the individual units. And that was a pretty big deal. But it's a different set of property code and some different set of rules. And that's why some of the language we see here that's different than the language in the 1-to-4 family is different because it's what the law says. You know, that's the language. We'll see this when we get paragraph 2. Now, we will probably in our next class, which I think it's in a couple of weeks, we're going to look at the proposed changes in the contract forms that the broker lawyer committee has sent to Trek, and Trek has put them on the Texas Register. They're available for comment. And then in Trek's November meeting, they'll decide to accept them or not, because between now and the Trek's November 7th meeting, the broker lawyer committee will have had another meeting. They'll look at all their comments, decide if they want to make any additional changes or whatever, working through that. But there'll be some interesting changes. One of the interesting changes is paragraph 2 change that you're talking about, the new one. So we will make sure everybody has the red line versions of the proposed contract changes. So when our next class, we can look at those differences, because if we don't have any significant changes from the position that broker lawyer committee sent to the Trek, it's in their agenda, it's in all their material for their August meeting. Then what would happen in November is Trek would approve them for voluntary use and then create a mandatory date, which probably would be maybe February 1st. And then that point in time forward, you have to use the new forms. We'll look through and we'll deal with that in our next class, I think it's 2 weeks. Now, let's look at the condominium contract. What I want us to look at are those paragraphs that are different. And when you think about them, remembering what kind of piece of property we're talking about. Buyer is buying a cube of air from the walls in, ceiling down or up. Buyer is not buying the building. Buyer is not buying the land. Seller doesn't own the land. Condo owner association owns the land, owns the building. So you've got a very unique form of ownership. Seller still has some of the other common things. I mean, subject to disclosure notice, things like that. She'll do inspections, still have lease fixtures and all those kinds of things, but it's a different form of ownership. Now, you'll notice the very first change is in paragraph 2, where we describe, we have the legal description. And in the 1 to 4 family contract, this is where we identify the land. You got a lot and block, because remember, there are 2 forms of legal descriptions in Texas. Lot, block, and plat subdivision that meets and bounds. And here, notice that we describe this entirely differently. We have, the condominium unit improvements accessories described below are collectively referred to as the property, which is a defined term, just like in the 1 to 4 family. So you have a condominium unit, you have a unit number, a building number, and then the condominium project. And then you got the location of it, where it is, and then you got an address in the city and the county. And then it references to the declarations, which is kind of what Edgar was talking about earlier, which we'll talk about in paragraph 2, where we deal with the documents, both the documents and the resale certificate. We have in that first paragraph, still in paragraph A before number 2, parking areas assigned the unit are. When I talked to the attorneys about, and I was talking to one of our, adjusters, these are the people that we have a lawsuit that they deal with, a lawsuit and so forth. I was talking to her, one of them last week. Whenever I have a chance to visit with them about some of the things, I always say, so what are you seeing out there now? What's your big issue? And I asked her specifically, says, because we've got like condominiums. So what do you see in the condominium area? She says, our biggest claims are dealing with parking spaces and storage areas. Says either the seller doesn't know what he has or he misrepresents what he has. And the buyer thinks he's got something different than what he's got. And he says, and we find this is one of our biggest claim amounts is, it costs us tens of thousands of dollars, was dealing with buyer bought the property thinking that they had certain parking spaces that they didn't have. And they said we had to make arrangements with the project to get some parking spaces. And it cost us money because the buyer had sued the seller and had sued, the listing broker for misrepresenting what it was. So right here in paragraph 2, we talk about parking units, and we can also talk about storage. So if you have a listing you need to be daggum sure that the seller really knows what his parking units are, parking spaces are. What are they? How are they identified? How they're located? Because buyers have a tendency to think, oh, here's that parking space that's right in front of the condo. So that must be my space. May not be. Yours may be 2 buildings over. And they'll all have a particular thing. So you need to make sure you do that. Same thing with your buyer. Your buyer needs not just presume that, yeah, here's what I've got. They need to make sure that they go through the process and they truly understand and it's identified in the contract what their spaces are. So don't treat it casually that, we all know exactly what the spaces are because you may be wrong. James?
How would you verify that? The parking spaces for that.
Well, when you talk to the seller and he gives you that information, say, okay, how do you know that? How do you know that's your space? Show me in your legal description for your property, because it'll have it in there. It'll have a parking that's identified with the unit. You say, well, I've always worked there. Nobody's ever saying I've always used it. No, I say, it's not enough. And make sure your seller understands the liability the seller has. Now, you want to make sure that you've got as much good documentation as you can for your seller about the parking spaces. So if buyer decides to come after them and we've got some protection there, doesn't mean they still won't come after us as the deep pocket. But you've got a little better protection as you work through that. So you've got to really do it. And you make a judgment call when you're talking to your seller, how confident you really are about what they've got. That's the case or not, but you need to make sure you've got that. Yes, ma'am.
Bob, I'm confused about the townhouse and the condo. I bought a condo in Highland Park before. So in the sheet, they say they said it's a condo like townhouse. So how could
See, one of our challenges in the business is we sometimes use condo as a marketing term.
Okay,
And doesn't really mean it's legally a condominium. What you've got to do is determine which it actually is. Is it a condominium or is it a townhouse? The real determinant is who owns the land.
Mhm.
And you go to the tax roll and you pull it up and you see what the tax roll assesses, what the CAD assesses for land.
so.
Because if it's condominium, the individual owner won't have any assessment for the land. They'll have a pro rata of the whole.
Okay, so townhouse, we could order the survey, they have the land.
Order what?
Could order the survey from the title.
Sure, because in a townhome, you're going to have a survey for that county. You won't have a survey for the individual condo unit.
Okay, how about the apartment? Some.
You don't own
apartment-
apartments. There's no ownership for an apartment in Texas. The closest you have to that is cooperative. And we've only got about 3 of those in the entire state. One of them down on Maple in Dallas. But in Texas, you don't own apartments. You do in New York, but you don't own them here. So you can only own, as far as real property, it's either a condominium or it's not. It's a single family home. And you really look at who owns the land. In a condominium, the condo owner association owns the land and they own the building.
Thank you.
And that gets to be a challenge. Many times you'll have a seller, a listing agent who will show it as a, single family and it's a condo. Or they'll show it as a condo and it's not. As a general rule, the title company, when they get it, will be able to determine which it is. I was talking to one of our title company folks, one of our better title companies. And I asked him, I said, so what happens when you receive a copy of the contract on the 104 family? And then you discover after you've gotten the contract that it's actually a condominium? What do you do? Well, we talk to the lender and we talk to the agents. And, we say to the agents that, you need to change to the correct contract. Because as we'll look at here, there are things in a condominium that are specific to that form of ownership that you don't have on a 1-4 family. There's some things you've got in the 1-4 family contract that don't apply to a condominium. Like the seller disclosure notice. Well, not seller disclosure, but like the survey, which we talk about the survey, you don't have that. Paragraph 6C in the condominiums, we'll see you don't have a paragraph 6C that deals with surveys. So it's one of those things that what you should do is change the contract form. Because it impacts on so many other kinds of things. So in paragraph 2, where we talk about, property, we talk about the unit, all that, and we get to improvements and accessories. Those are all the same in this as they are in a 1 to 4 family. We get into 2B and 2C, we get into the documents. And one of the things that we'll realize in the 1 to 4 family contract, you have an addendum for membership and mandatory HOA. You don't have that for a condominium. All condominiums have a homeowner association. Not all single family homes. I'm just using that distinction, single family homes as opposed to condominium, although condominium is still also single family home. Generally. So as you go through this, because every condominium has a condominium association, we have it in the contract as opposed to an addendum. In fact, you'll see on the HOA addendum, track addendum, it says not for use for condominium transaction. It's at the very top, tells you not. So they've split this up into 2 sections, paragraph B and paragraph C. Paragraph B deals with the documents, which is all the bylaws, the rules, all those things. And then in mandatory HOA for single family, we talk about the subdivision information, which includes all these bylaws, all the rules, financials and everything, including the resale certificate. Here we split up the docs from the resale certificate. And so we have under paragraph B, buyer makes a choice here, they either have received it. It says, and buyer is advised to read the documents before signing the contract. If they've received the docs. In B2, buyer has not received a copy of the documents. Seller sells to deliver the documents to buyer within. This is similar to the HOA addendum. A number of days we want to give the seller to provide the docs. We need you to get these at a certain time frame after the effective date of the contract. It says buyer may cancel the contract before the 6th day, which means 7 days, after buyer receives the documents. Now, this is a big difference, and this changes what we do in paragraph 21, the notices paragraph. If buyer may cancel the contract before the 6th day after buyer receives documents by hand delivering or mailing written notice of cancellation. Now, go to paragraph 21 in your contract. And these are notices from one party to the other. And it gives the ways that it can be effective once in writing, mail to, hand delivered, transmitted by fax, electronic transmission possible. So notice from one party to another can be done any of those 4 ways, unless buyers canceling the contract under paragraph 2. You can only do it by hand deliver or mail, registered mail, return receipt requested. Those are the only 2 ways the buyer can cancel. So that means if you've got a condominium in paragraph 21, you're going to need an address or something for that cancellation to be delivered or to be mailed. So you're going to need an address for the seller. Now, I also still want the agent's email if we want to get these notices for reasons I've talked about before. We're now going to have an address in a condominium.
So do you want to have the same, like kind of you do in paragraph 1, you want to have a lot of, is it a lot of days in there, 21 days, 14 days, all that, because it takes so much time or no?
Yeah, you could. Depends a little bit on what's going on with the HOA. Yeah. But does everybody see how, because of, if the reason the buyer needs to send notice to the seller is you're going to cancel under paragraph 2B or 2C, that changes what we have to have in paragraph 21. And by the way, in a condominium, you're going to see title companies really pushing this. They're going to require, say, you know what? Because this is a condominium and because this is something that might happen, we need an address. We need a seller's address. Otherwise, if you don't have a seller's address, buyer can't cancel on that provision. Sending a notice to the agent doesn't do it. So you've actually got to have something that you can and deliver as you work through the process and be able to deal with that. Because you got to be sent to the seller. It's generally held by most of the attorneys, certainly all the title company attorneys, that the imputed notice situation that we have when it goes to an agent, same as it goes to the client, doesn't apply here. Has to be sent to the seller, it has to be sent in one of these two ways, or both of these ways. So make some changes here as you go through that. Any questions on this part? So being aware of that, if you got the buyer and the buyer saying, I don't like this, or I decided I don't want to buy the house or whatever, and they're going to terminate under this provision, you need to know how they have to do that, which means you need to have already made sure contract was done correctly in a way that this could work. To your question.
Yeah, so how long has it been like that where you have to hand deliver it or mail it?
As long as we've had condo contracts in Texas.
Are they ever going to update that?
Well, as a matter of fact, it's interesting. In the proposal for the new contract, or the changes right here, one they changed before the 6th day to the 7th day. They also change how you have to deliver that. So that's proposal. Now, I haven't asked one of the attorneys on the committee yet if that means they've actually changed what's in the property. The reason we have it like this is because that's the language in the property. It'll be interesting to see if they actually went in and made the legislature made that change in the property code to change the language there. So it really needs to be changed, I would agree, because this is a real problem. Because people,
There's no paper trail.
yeah, there's not, people aren't paying attention to the difference here. And many times, how many times have you seen a transaction in which paragraph 21 wasn't completed at all? There's nothing in there. Well, it's a condominium and you got nothing in there, I can't terminate under this provision. What are you gonna do? So you got a real problem you work through. So it'd be much better if I could change it to where you could email it or electronic transfer, whatever.
I'm sure there's been instances where someone's done it through email and a listing agent or a seller has accepted it. I mean, it's only if the seller in that age.
Yeah, in a case like this, it's only when there's a dispute on someone's ability. Could be the seller is happy to get out of the deal. Oh, yeah, you want out of the deal, fine, not a problem. But if they dispute it, they say, well, technically you didn't follow the rule here. Yeah. If you had to get finally to court or something, the judge said, well, yeah, I read it. Did you read it? No, I didn't read it. I'm supposed to read it. That's why I have an agent. I don't have to read that kind of stuff. They explain to me everything, how it works. So that's in 2B, and that references to the documents in 2C. Much the same kind of language, except we're talking about the resale certificate required by the parties. Seller spent no more than, and here they establish a timeline on when this resale certificate has to be completed. Now, that's not a timeline that works for all lenders or even all title companies. They say 3 months is too long. They want a resale certificate within 30 days. So you need to always make sure you talk to the title company, talk to the lender and say, what kind of timeline you want to deal with it. So the paragraph C, again, C1 or C2, either they have it or they don't have it. And C2, if they don't have it, then we got a timeline here for when they want it. And then the buyer can cancel the same language 6 days before and delivering or certified mail return receipt requested. Yes.
Where did that resale certificate come from and which agent would be
Well,
responsible?
it comes from the Condo Owner Association.
Okay, because I've had them drag their feet to where, we didn't realize it was not there.
Well, who generally requests it is the title company.
Okay, good. All
The
right.
title company is going to request it from the HOA. So what we've got under B, under C, where you've got a third choice there. Buyer has received seller's affidavit. The seller requested information from the association concerning its financial conditions required by the property code. And the association did not provide a certificate of information required in the certificate. Buyer and seller agreed to waive the requirement for the certificate. And then it goes on into D where it talks about if it reveals a right of first refusal, this creates a situation that can create another right of termination for the buyer as you work through this. It would be really prudent for you, representing buyer or seller, to read this paragraph 2B and C and D And make sure you understand what this does for the buyer and the seller as you work through that. That makes sense, James?
Yes, Bob, on paragraph D, how much time would you typically see in that blank, the number of days after the effective date for the?
I think that'll depend a little bit on the association itself. If it's a larger one with management, that you're pretty good about that. If it's a smaller volunteer one, it takes a long time. It's really going to come down to how the transaction, what kind of closing date you're dealing with. You're at least going to be wanting 10 days. But I can see putting 20 days in there.
Is that something that would be in the questionnaire, the condo questionnaire that?
I don't know. I've never actually read the condo questionnaire. I think it's probably a good thing for us to get the lender to told him to give us one of those. So
It's pretty detailed.
is it really?
Yeah, I'd suggest everyone look at one.
Yeah, and see how much. Yeah, not look at it to be able to advise your clients to understand all that stuff that's on there. Yeah. Good afternoon, young lady. Were you like in the neighborhood? Thought you'd drop by?
No, I'm just very charty. I had the plan to be here at 1:00. It didn't work out, but better late than never, right?
Yes, very much so.
Thank you.
We're glad for you to sign in and hopefully there are documents there.
Sure.
Anyway, we're glad to have you here. So I think it's going to depend a little bit on, just like in the manager HOA, how much time you put in there. Depends on what's going on in the transaction, work through. But again, this is one of those things at the very end that says, you know, if right for his exercise, this contract should terminate and or somebody refunded the buyer. We keep having all those things in there where it appears to say, buyer gets their money, and you just say, really? I don't think that's how that works. Not without the title company's permission. Okay. Go to the second page. Notice that we still have the same information in paragraph 3 of sales price, paragraph 4 of the leases. We don't have C, we don't have environmental lease for an individual unit. So we have residential leases and fixture leases. You work through that. In paragraph 6, in 6A, 1 through 9, you know, we've got those exceptions. I really didn't get a really good answer. And you know how I'm really a nice guy and very flexible, especially when I'm talking to attorneys. One of my favorite attorneys questioned why in a condominium contract we have 6A8. Because number 8 deals with the survey. And we don't have a survey for an individual unit. So I said, so why is that? He said, well, underwriters going to look at it. They're still going to deal with these situations for the project. And he said, even though the underwriters look at it, and he said, and a buyer may purchase this, but he said, but frankly, I don't know why they would, because it's worthless. You don't have a survey. So I don't know why you would do that, but it's there. But one of the things you're not going to have a problem with is in the condominium, the buyer decided if he wants to amend the exception. Because in number 8, you don't have that place where you amend the exception. So you have to deal with that. Because as you'll notice, when you go to page 3, you don't have 6C and with surveys. You have 6C dealing with objections, which in the 1 to 4 family contract, objections to 6D. Because you know, and we don't have surveys, so you don't have 6C 1, 2, and 3 about who's going to pay for a survey as you work through that. You won't come to your fifth floor unit and see little red flags around the survey on that. Good problem. Question on that so far? You work through it? Anything you have there? The rest of the contract deals with the same issues because the rest of the contract you're dealing with the same, you know, ownership issues. You'll notice when you get to page 7 of the contract, We've already talked about paragraph 21. In paragraph 22, you know, we'll have all the normal kinds of things that you have in all the rest of them. What you can have, that you don't have in the regular 1 to 4 family, is you may make use of a condominium addendum under certain circumstances. But otherwise, you've got all your other normal kinds of things. Any question on any of that so far? You good? What's the,
Hey, Bob, I have a question.
yes, sir.
So on 21, where we said we must have a seller's address over there.
Yeah.
So that if we cancel it, if the buyer cancels it from paragraph 2, is it a good rule of thumb to have an address for both of those? Since they're blanks, I mean,
Well-
wouldn't that save you a lot of time?
You could, however, the only provision that you have to have a seller's is when the buyer's going to cancel a contract. So that's a provision that you need to make sure you deal with that. If they're going to cancel the contract,
Right.
that's how you. It looks like we have our title company people showing up.
You want me to come in?
Yep. See Carla and Megan and there's Scott. Great timing. All right. Hello, Scott, and there's Carla and Megan. Thank you very much. He's going to come in, he's going to tell you everything you ever wanted to know about the legal side of condominiums.
Y'all been great.
Scott Rooker is one of the fine attorneys with Republic Title. He's been here a number of times talking to us about all kinds of wonderful things. Hey, you doing, sir? Good to see you. Good to see you. Thank you for being here. We've just kind of gone through the condo and contract and shown some of the differences in this and the 1 to 4 family. Please.
Too late to.
Oh, it's a walk. Yeah, you want to go? Yeah. Jana, since you want to make sure we know how to do this. Email?
Yeah.
Make sure I can. It's first.
Turn off.
Okay. Okay. Okay, let me go do, while you're doing that, let me go print out the, when did you send it?
Just a minute ago.
Okay. Let me go see if I can pull it out and print it out. That's that guy that I am, it shouldn't be a problem.
All right.
Take a quick 5-minute break.
No, I'm looking for something like word. Yeah. Stop right there. None of our- Yeah, she's not in.
Can you just passport for a KW account? But he's going there to sell folks right now. With my
Not planning for them, that he can send it out to everybody after for us. That helps. I do.
Oh, good.
Yeah, this way.
Let's say half the class. It's something to follow along with.
If he wants one, and he so.
Yeah, no, it's.
Yeah.
You're really not complete. It'd be really crunchy and obnoxious.
But I just think that can cut it. And then.
Oh, yeah. Yeah. Yeah, they'll send it to us and give me that later. Uh-huh. But this is, thank you for doing this. This is what you. Yeah.
Right here, your password's not working.
I don't know which password you want.
The KW one,
But I know what you want.
your Bob Baker at KW.com.
She is Sue to figure out what this. And the one you see the one I gave you, she usually.
Yeah.
That's one.
You have it on your, can you email it on your phone? Yeah.
Okay. Oh, you want to put it up on.
I'm not gonna run down the hall if you wanna.
Okay.
Whatever you want. Oh, sure. Yep. Standing there.
That's right. Big price. No, it's pretty. Oh, nice.
And then. I go ahead, yes.
All right, everybody. Hello. Again, my name is Scott Roper. I'm with Development Title. I'm with the corporate office and I've taught here a few times before, I guess. So hello again to me before. So Bob invited me over here to talk to you guys about condominiums and what a condominium might look like. So from my understanding, did you guys go over the contract? Okay, did you touch on how to give notice of termination and things of that nature? How important paragraph 21 is? I almost any class I teach, it doesn't matter. This class, survey class, home security class, whatever class I teach, I spend about 5 minutes on paragraph 21. I'm sure Bob did as well, but it needs to be filled out. Okay, bottom line, it has to be completed. Whether that's just putting in your email address, the principal of the parties, right? Your buyer and seller, you want to put their email addresses in there. The reason why you want them getting all the critical information and all the critical dates and all the documents so they can timely object and look at them. You just put your information in there, guess who's potentially liable for any misses, right? Probably
Did
you,
Send it to
right?
email or did you do drive?
So that's got to be filled out, right? Now, when you're looking at the condominium contract, obviously it's a little bit different, right? And now you have to put a full address, unless you're going to deliver it to them by hand delivery, right? What does that look like? You got to take a selfie with, as you're delivering something. Like, how do you prove that, right? If they, how do they prove that if something were, if they're going to object to it or something of that nature? And I think they're going to, I'm hoping in the next Trek meeting, I think they're going to make some changes to that and finally bring it to the 21st century with regard to email. Do you have a question?
How do you handle disclosure of email addresses? During negotiations for both parties. And we will search each other on Google searches, social media. Is there a way to preventing that or insulating your clients? If you're concerned about something like that occurring?
I mean, if you're concerned about their identity, then sure, you can put your information in there and leave theirs out. But I mean, they're going to be the principal on the transaction, the buyer or seller, unless it's in a trust. You got the trustee listed, right? If you're dealing with a high profile, either athlete or celebrity or something to that effect, we see that a lot. It's typically going to be in a trust. Putting in an LLC, typically it's going to be discoverable eventually. You just go down the rabbit hole of the Secretary of State. Putting in a trust really creates the anonymity that they're looking for. But as far as preventing them from negotiating with each other, no. I mean, they can call each other, they can instant message each other or find somebody on Facebook, and there's really nothing to 100% combat that. But obviously, you'll know, I think, fairly quickly if they've been doing that, going behind your back, and I'm sure you have a decent listing agreement which says you can't do that. So anyway, no, there's not. And if they ask for what, if they ask about it, they say, well, I don't really want to put my information in there as far as address or email or phone number. If that hasn't, just explain to them the importance of paragraph 21. And then I would have something in writing then at that point in an email saying, yeah, you're kind of getting legal there, but ask Bob, but something like a hold harmless situation where you're not going to come back and sue me if I forget to forward you an email. I mean, that's kind of where you would need to go with it. Because I certainly wouldn't want that full responsibility to, God forbid you either miss it, it goes in your spam folder. Oh, I never got that document. I mean, that's everybody's favorite word, right? Favorite sentence that you hear. Oh, I never got that document. Oh my God. I mean, you and I are both, we sent it 3 weeks ago. Oh, it's day of closing. Oh, what's the commitment? We're all, I mean, you can forward it to him. You can say, here's your commitment. Please read it. That's about all you can do. Well, what is it? You read it. My first year of law school, first day, first hour, first minute, my professor wrote up DTR on the board. Hey, DTR, was I supposed to know this already? I'm failed. He said it's a duty to read. You have a duty to read. You're gonna have to read it, right? And obviously we're here if they want substantive questions. I don't understand Schedule B, item 10C. What is that? Well, we can read it out loud together, and then you call your favorite attorney. Hopefully, I'm happy to take those calls and try to walk them through it. Even myself can go only so far, right? I can't really tell them what to object to. There's a paragraph in these contracts, paragraph 23. That's your spot to put in an attorney. So I would just let them know early on, look, it says paragraph 23, there's an attorney paragraph here. It could be, we could get into a situation where you might need counsel. I don't know what that is. If you're digging into the Schedule B requirements with title, or if there's an issue on title that you're concerned about, you may have to hire an attorney. So I would let them set that expectation at the beginning. Right? So you're not 2 weeks in, you're like, well, you probably need an attorney. Well, you didn't tell me I was going to need an attorney. Go ahead and have that conversation from the beginning. Right? And it's in paragraph 23. So make sure you walk them through that paragraph and what it means and what it is, and that you may have to consult an attorney. And in fact, in your contract, and even in this contract, I think it's paragraph 6, what is it, 6E1, I believe, right off the bat, it talks about you might need an attorney to review your documents. Right? If you get a title commitment, you need to consult an attorney. So it's out there, it's already there. So again, I would just set that expectation for them from the get-go, yes.
Well, this one always gets in the way. So what do I need to, it's when you're signing joint or when do I need to contact the attorney? And then you get here and say, well, I haven't spoken to an attorney. Still think I should. I mean, this one drops the brakes.
Yeah.
So if they haven't, you just don't fill it out. If they want to talk to you, they've spoken to you, and then do they disclose?
Well, they couldn't fill it out for me per se, because I couldn't
No.
represent them.
No, but they would say, I've spoken to you and fill.
Yeah, if I was an outside counsel, somebody else, some attorney, sure, yes, this is my attorney going forward. I mean, but it's for representation.
It's only for representation.
Yeah.
Okay.
Yeah, if you just talk to your neighbor who's an attorney, I wouldn't put that information in there. Good question. But I mean, basically, you're saying they're involved and they're going to go in our system as representing buyer, representing seller. And we're going to be emailing them throughout the transaction. And neighbor lawyer is going to be like, what the heck is all this? I just took a phone call. And then they'll start billing.
Yeah.
They love to do that.
There a whole semester class in law school on billing?
It should have been. It should have been a lot in law school, but.
What page are you technically on?
One,
Okay.
we really haven't even started.
Okay.
I'm still on paragraph 21, Bob. Okay, well, my 5 minutes soapbox, paragraph 21 and 23. Well, so what is a condominium, right? It's defined by the Texas Property Code, and it's chapter 82. Okay, it's chapter 82 in the property code, and it gives your definitions of what common elements are, what limited common elements are, the declaration, right? A condominium regime has to have a declaration. Okay, they have to have a declaration filed of record. And so that's almost one of the easiest ways to figure out, well, is this a condominium or is it a townhome? Bob and I talked about this a couple of days ago. What's the distinction between townhome and a condominium? Well, it's going to have, if it's a condominium, it's going to have a declaration. Because the declaration creates the HOA, if you will. It creates the regime as to how it's governed. We had a situation a couple of weeks ago, it was down in Park Cities, where this builder, it's kind of a fly-by-night builder, 2021, market's hot, just threw up 8 townhomes. Or he's feeling it, build them as fast as they can, one through 8. They get halfway in it. These are townhomes. Get halfway in and say, you know what? Let's make this a condominium. Let's make this a condominium. So they hire one of the most sought after, or the most used, I should say, law firms, because I saw who did the declaration for the HOA, and they have a recorded declaration. Well, now it's a condominium. Well, what about the first 2 they sold? Because now this guy wants to sell. He said, well, I thought it was about a townhome. Then you look at the legal description, it talks about a unit, right? You look at the improvement that on CAD. Now, CAD's not, it doesn't govern us. It's not legal per se, but it is helpful to look at. CAD has the owner with the value of the land and the improvements, right? Not a percentage of the value, right? It's just they own the land. So what is it? And they wrote it on a condominium contract. No, I'm sorry, on a 1-to-4 contract. But then the warranty deed talks about unit and condominium. It was an absolute mess. Right, it was an absolute mess. And that was done right in the middle.
What happened? I mean, because obviously they didn't know. They don't know land, and then now how did they get it down?
Tacos.
Oh.
That's my placeholder answer. Well, I told them to go back to their title company and figure out what in the world happened, go back to the builder. Now, from a legal perspective, the first two, whoever is sold without that declaration, right, those are townhomes. Okay, because they were not subject to that declaration prior to their ownership, okay?
They could sell and still sell that.
Yeah.
Okay.
Now, the declaration, the rest of the units, the other 5 units, would have to get the other 3 to join in if they want to. So right now, you probably have this all attached 1 through 8, and you kind of have a subdivision, if you will, in and of itself.
How?
Not sure how that's actually going to eventually play out, but that's legally, that's how that's set up.
What's the addressing of their days of community property? The property, I guess, would be access to it if it was a larger development or something like that.
Right. Yeah, so you're gonna have 3 through 8 that has common elements and limited common elements, and you're gonna have 1 through 3 that have free use of their property, right? But not the next door neighbors, right? So my point is, how do I know what this is? Well, reach out to us. We run very quick. We can quickly tell from a title search very quickly whether it's subject to a condominium or not. You can look at the deed. Sometimes we'll tell you as well that it's subject to in the legal description. So we can pretty quickly tell yes or no if it's involved in a condominium regime or not. The thing that if I were representing, really seller or buyer, right? Buyer, presumably here, the biggest document you want to look at is the declaration, right? The declaration will cover all your uses, all the uses that you can do with the property and all the things you can't do with the property. And the can't do with your property is probably the biggest. They can limit the size of dog you have. They could limit if it's going to be a VRBO, right? Or a short-term rental, or if it's just an investment. They're limiting investors now. I've heard some of them, Bob and I were talking about this. They're capping them to 20-25% of ownership, right? Can't be by an LLC because they think that's going to be, that's an investment property, right? Now you could perhaps maybe try to explain to them, no, I take it, it's a personal, it's my residence. I do have it in my LLC just for protection. Some lawyer told me to do it. And no, it is my home. It's my homestead, if you will, even though LLC can't have a homestead. But you could try to, my point is you're explaining to the HOA, if they're up to that 25% cap, maybe you can explain to your buyer, look, if you're dead set on this LLC, they deem that as investment property, but maybe we can convince them otherwise. But realize your window to do that. What is it, 6 days? 7? It's pre-printed before the 6th day. You know how quick that is? What if you get it on Wednesday? Your buyer looks at it Friday. Well, now you got Saturday, Sunday. When's your last day? I don't know. How many days is that? Monday? It's quick. It's before you know it that those 6 days are up. And you're having to go through. Have y'all printed them off before and run out of ink while doing it?
Yeah.
That's 300 pages or more when you're dealing with something. So if I'm representing a buyer, I'm telling them, how are you going to use this property? Right. And that's also in paragraph 6, you can object to what, the following items that are limited to use. That's a good place to put that objection. How are you going to use this property? Is it an investment? Do you have a big dog? What are the items that are important to you? Is the common elements and limited common elements. Do I want a garage? Do I want storage? Right. Some of these condominium regimes have parking that go with the unit, and they could have parking and storage units that go with the unit. Is that important to the client? put that in there, that they want the ability to, take ownership of one or the other, right?
And can they sell those storage units?
Oh, I'm gonna get into that in a minute. Oh, gosh,
That's Donna. She likes it.
yeah,
Lots of good questions.
yeah.
And that's good.
But my point is, that's a good opportunity in that paragraph 6 to put how your client is going to use the property, right? And this applies to, 1 to 4 family as well. So you want to put those items in there. And then the important thing is that declaration is for your client to go through those. Now, again, you're not attorneys. You can only do your best. Now, if you are to go through it, but this is the other thing that we talk about in your ethics class is geographical competency, right? You're required to have geographical competency when you are buying or selling. You got to know what sandbox you're playing in, right? So hopefully you sold a little bit in there or bought, helped represent a couple of buyers in there. You know it. You get Bob to help you or somebody else. You maybe have a co-agent with you.
What's our standard phrase? Call an attorney.
Yeah,
The attorney has to review it.
that's the scary part.
It's not a direct document,
What?
those documents. When
Oh,
we get
yeah,
those, yeah.
Right. Right.
That's the scary part. As the agent, whether you're sellers or buyers, you said, yeah, we're supposed to read it all, but do we really even understand it? And they're huge.
Yeah, not for you per se. I'm talking about for your client,
Okay,
principal.
but couldn't they come back at us and say we didn't explain it or we supposed
In
to?
writing, you're going to advise them to seek legal advice.
Okay,
So just, you're going to always do that in writing, especially you, James.
How bad about that? If your DTR, your comment on DTR was to the client.
Correct.
Right? That's
Yeah.
their duty to read.
Right.
Now, can I ask one question on the declaration?
Yes.
They can be modified when that's looked at, or the modifications in order and attached to the declaration document, whether you have to hunt and peck all the material that's sent to you. Is it sort of standard to sort of group any revision to the declaration at the same?
Yeah, so that'll be attached as well as amendments, and those will also be in there. You'll see, if you see in the title commitment, you see Schedule B, you look at B1 there, and it's got this thick of volume and page numbers, and it has one condominium regime filed in 1982, and then it has a whole bunch of dates after that in volume and pages. Those are probably amendments, right? And they're all going to be with that declaration. Typically, that's why they are over 500 pages. Because they added a unit. We do this whole thing, here we go, they get their feather pen out, sorry, no, I'm just kidding. They just add an extra page, but that's why, they'll be in the declaration themselves as well. That's important too, right? Are there any upcoming, usually you're hoping that's gonna be on the resale certificate, really for the seller. Does your seller know of anything that's happening, that's coming up in the condominium regime, right? Are they looking to get a pickleball court? And that's going to be $100,000, right? Or something else that is in the purview of that year that your buyer may not know about, right? And that's also something the buyer would want to ask the HOA. I would highly encourage the buyer to reach out to the HOA if they'll talk to them, if you can get a hold of somebody. And if you have good contact information, that would be greatly beneficial for your buyer to ask all these questions straight to the HOA, right? If they have the concerns, well, I have 4 dogs. Well, you only have 2, right? Yeah, it looks like Ace Ventura's apartment, right? You can't do that. I would guess. Such a classic. So again, they're gonna.
That's this off, Janet? We got somebody else who's gonna do it?
Yes, Jennifer Timberville.
Good. Okay, so you know how to move it up to the next page?
I have to go to the.
Oh, there's probably like.
Call.
As well, you should.
Yeah, that's my job.
Yes.
Going back to the parking spaces in the garages, right? So those what they call limited common elements are parking space. So those are parking spaces that can go with the unit. The storage units that can go with the unit. Perhaps your balcony, right? Even if it's a shared balcony, that's a limited common element, right? It's kind of like your own exclusive use. You have this plot of land, right? You have an undivided interest in the land, which means I can move around in the common elements that are common to everybody else, right? Who owns something. the fitness center, the pool, the pickleball court, the tennis court, whatever, the basketball court, whatever they may have. Those are my common elements, right? But the limited common elements are, hey, that's my parking spot. Right? That was included in the purchase price. The problem becomes when they try to sell it. This happened down, oh man, it was down downtown Dallas, one of those high-end condominiums. And people had, went with the unit, parking spot, garage unit. People started selling off their parking spots. Do you think they recorded them with the Dallas CAD and they were properly indexed? Right, they weren't. These parking spots, storage units were all over the place. I mean, where did you sell? Well, who'd you sell it to? Well, my neighbor down the hallway here. He has like 4 of them. And then he goes back and then rents them out to other people. So this guy's printing money over here. It was a big mess. And the regime, the condo declaration will control those items. Whether it can be sold, whether it can't be sold, or whether it just goes straight with the unit. Usually it's going straight with the unit. There are few and far between that will speak to, you can sell off your storage unit, you can sell off your parking spot. So again, it's something you have to look into the declaration to figure out what you can and can't do.
But you're saying those sales that weren't recorded are not reflected in the declaration either.
No.
Can you, if you get the garage or the storage unit, can you rent them without transferring? But how can you transfer the ownership of a garage or a parking space if you don't? How can they separate that out of, if you own that?
They did a bill of sale, basically.
Okay.
They went on legalzoom.com and created their own document.
But
But they owned it.
Can you rent? I mean, you can rent. It's legal for you to.
I would assume you can. Again, check your declaration, whether they prohibit that or not.
Well, who would write that contract if you were, within the HOA, if you were gonna do it legally?
In that instance, when you don't have the parking unit anymore or the storage unit,
You want to sell it
yeah.
and,
In that instance, we were asking the seller to go back and repurchase it.
right,
Or to sever it, and they're gonna have to do an actual deed, if you will. Which again, the declaration even allowed it.
declarations have it all.
It's the Bible to your condominium, right?
So is the title company going to do the search to determine if what this unit has is supposed to have, it actually have it?
Yeah, because it was there, and indeed, then it went away, then it came back, and then we lost it. And we said, where is it? And I think they had filed it or tried to file it. It was indexed wrong. So it went to another, it was a mess. These were like multi-million-dollar deals, so we're trying to find where they store change. I mean, they could try. Probably be a legal process to do that, but. Yeah, they certainly could, if it was prohibited and they were mad at us. I mean, I think you guys all know HOAs, COAs, they can be as hard as they want. In the straight.
Like that, it can't tell how long something like that might take to resolve. So do you think the transactions fall apart?
Oh, yeah. Yeah, or hold on for a minute.
So is that something you would assist with in doing a title search, or that's not the?
Yeah, I mean, we're trying to track it down, trying to help, but there's only so many rabbit holes we can go down. Just had to ask the seller what happened here. And if it was further down in the years, we'd go back to we'd ask another title company if we could write on their paper if they insured it. Yeah. What else do you guys have? I mean, that's kind of the quick overview.
Where do we find the declaration?
You find it?
Yeah.
Well, it's recorded, record.
Is the title company gonna pull that up?
Mhm. Yeah, it's gonna be provided to you, the resale certificate, the declaration, the bylaws, the rules of the association, those are all those documents. They'll be sent to you within, the blank days, whatever it is, or after your client receives it, then they have that time, that ticking time there, to review it. Ask questions about it, object to it, or just terminate. Now, if you're up against it and you're saying, well, I didn't read it, I was out of town. Sure, you could ask for an extension. But it's such an easy way to get out. You might as well just terminate or negotiate an extension, really. Especially if you have to terminate by sending them written notice, return receipt request, a little green card. That green card is important to get back, by the way, because if you don't have it, it's not legal notice. I was in court waiting on a hearing. And there's a hearing before mine, and an attorney representing the landlord said, yes, we sent notice for the eviction. We sent it certified mail, return receipt requested. And the judge asked, well, where's the green card? I don't see it in any of my papers or in evidence. Start stealing one of these.
What do I do with that?
He didn't have it. He's like, Judge, I'm sorry, I don't have it with me. He said, well, counsel, as soon as you get it, you come back. Dismissed. Guy had the green card. I think she had a question first. I'll get to you. Do you have a question?
Well, it's kind of random, but it's about square footage
Mhm.
and balconies.
Okay.
And so some of the appraisers I've spoken to about square footage differences, well, they probably included the balcony, or they didn't include the balcony. And so some do include the balcony in square footage, even though it's not air conditioned.
I mean, I guess that'd just be up to case by case deal. I mean, it's a limited common element, if you will.
I think it would be
It's not the unit per se.
with the HOA.
Yeah. I mean, again, that'd be a case by case scenario of who's looking at it.
James, you had a question?
Just real quickly, just go back to the earlier statement. Did you suggest we as agents should read this material? Not necessarily advise and consult on it, or just give it to our clients and let them read it?
What? What?
Hey,
You know me better than that.
no, I'm more than asking.
Are you asking Scott says, would he recommend that we review that 500-page document?
Be familiar with it, not necessarily advise.
No. It's a rattlesnake. Get out of the room. I know that's a
I want to
rather,
make sure it's clear to
unkind.
everyone in the room what your position is.
well, does that not make sense? I mean, all we got to do is we just went through this and it was dealing with objections. And we looked at, well, unfortunately, well, our agent looked at the condo, it's when the condo just regular, looked at the docs. Because we had an investor who was buying it, putting 6D on uses rental property, which is not a responsibility of the seller. Buyers should check it out. Buyer did look at, there's 60 pages of the HOA docs, which is reasonable. He did look at it, and we missed on the 35th page. You had to own the property for a year to be able to rent it out. The first page, it kind of looked like, oh yeah, you could rent it out, but on the 35th page. And so we had a buyer, a client in a property who was going to own it for a year, but I've been renting. Fortunately, he was a good buyer. He understood he had some responsibility. We split the cost for owning that property for a year. Because the agent should say, you know what, you got to totally review it, totally check it, totally on your own kind of thing. This is where getting the buyer to talk to the HOA is really important as you work through that. So, but here's the balancing act. Because I don't want to be unkind about this. You want to support your client. You don't want your client to say, hey, I don't nothing. And I'm just here to collect my commission. Give me. You want to support them, but you want to say, here's our challenge. This is a document that's a legal document. I don't have the training. I don't have the ability to interpret it. Plus, the Texas Real Estate Commission does not allow me to do this. That's unauthorized practice of law. And as I've mentioned in other classes, TREC actually has created an unauthorized practice of law working group. They did that this year that's actually looking at that challenge. So they're taking this very seriously. So we want to support our clients. Says, you know what, we'll do what we can here. You've got to take the responsibility. And if you can't do that, then you've got to have an attorney. You retain an attorney to review it for you. But you've got to know what you're getting into. And you want to do that in writing. You want to get some acknowledgement back from them in writing. It's terrible service to them for them to think they can trust you to know what it is. And that's bad service. But you can't do that. And, you know, I mean, and it's not a matter of not providing, not providing good service. It's a matter of doing something that frankly, you're not capable of doing. Because in addition to geographic competency, subject matter competency, you've got to have all that. It's just, you know, it creates a situation for a client that they've got this false sense of security, that they can trust us to take care of everything. And they need to understand that's just not the case. It's not that we don't want to help them or support them, it's their limitations. Here's what we can do. Here's what we're really good at. Here's what we cannot do. And I know all our attorney friends get tired of hearing me say this, but it's an automatic. I don't want much. Because they, well, what are we doing? Well, tell your client, talk to an attorney. Because 90% of the time, that's exactly what they need to do. Because we can't, our help to them is help them understand this matter is serious enough that it's step beyond the client agent situation and talk to an attorney. There's got to do it.
I wish I'd recorded that, but it's on Zoom, right?
Oh, yeah, it is on Zoom. So the other thing, you may want to, on this, I pulled up the condominium resale and the regular, because that's a different animal. Because, and you got that in your packet, the condominium resale certificate, because they deal with it a little bit differently than we do. So from a title company perspective, as you get resale certificate, all that information, is there anything on there that jumps out at you that we need to be aware of? Because, you know, we've got to have that, and we got that in paragraph 2, where we get resale.
All right. I mean, when you're looking at this one, you're hoping it's completely filled out. But 2, you know, you're talking about the capital expenditures, right? You want to look at that. Reserves for capital expenditures are this amount that been designated. Those are items that will get, you know, some pushback. So you want to understand who's paying for what. That's also in, I think is it 12A-C in the contract, right?
Is that 12A-1B? Seller concession?
Yeah.
That's 12A-1B.
Well, it's 12A-3.
Yeah.
Buyer's gonna, yeah. That said, the buyer shall pay any and all association fees, deposits, reserves, and other charges resulting from the transfer of the property not to exceed X amount. So they give the access. Right, so they took the bucket, and I'm sure Bob has told you that. They took all, you know, there's this type of fee, there's dog park fee, is that a reserve, is that a capital expenditure, what is this? That they're charging all these fees, so they decided to say, look, it's going to be any and all association fees, deposits, reserves, and other charges, but it has to result from the transfer of the property, right? If this charge is being charged because I'm selling the property, that's where this number comes from. So
It's a big number.
correct. And so you have that, you're mirroring that paragraph with the condominium resale certificate and trying to understand the assessments, the reserves. And so this is more for your buyer to understand, here's all their expenditures, right? It's not just HOA dues per month of $200, whatever it is, $500, but it's all these items as well. They're being collected, or they have to be collected, right, at closing, and who's paying for those items. Again, understanding where you're selling for your seller, right, and understanding where you're buying when you're looking at these. That's where it gets into, we see it at the closing table fights, if you will, about the proration. This wasn't done correctly, or it was done correctly. Now, look, we have an entire HOA department at Republic Title. That's all they do. HOAs, COAs, it's all we do. So we have a massive index. We have a large library of these charges, of these fees, and they're, you know, as they come due, we keep a good library, if you will, of these fees. So when we get them, we pretty much know what we're looking at as far as the prorations go and how those are counted. But it's something you want to check as well, right? When you're looking at that for your client. Just checking the numbers, making sure they're right, asking the questions. To the HOA. And that was one thing I was going to tell you. You know, if I'm a buyer and my buyer is going into a condominium and I know that for a fact, I'm gonna ask the seller right before we even have an executed contract. Okay, you know, you're part of this declaration here. Is there anything that your seller, you know, knows about as far as renting or something, just to get a head start, if you will? My point is to get a head start. So when we get the declaration, we know where to look. Your client knows where to look to go, and perhaps a good contact information. I would ask the seller, who's a good contact at the HOA? Because my client buyer needs to talk to somebody. They only have 6 days to do it. That's what I would get. First and foremost, that's what I'd get is contact information from the HOA. So I know who to call as a buyer. I think that'd be a huge service for your buyer client. Hey, I got actual numbers and email addresses for the HOA. Here's the document. Here's the contact for the HOA. Godspeed.
Sooner you know that, the better.
Yeah. And so that's what I would highly recommend. I mean, before you sign the contract. I'd always make it contingent on the acceptance. Just give me somebody I can talk to at the HOA department. Because again, like I said, there's only so far. And no, we're not going to read the 500 pages either. I may tell them where to look. I may tell them, you know, it's in the restrictions area. You might want to look at prohibitions. But I always tell them too, when I talk to your clients, you need to call the HOA. Ask them. Ask the HOA if something's allowed or not allowed. But again, ask those questions early on with your buyer though. How are you going to use this property? I think it's really important.
Have you heard of any unusual uses for condos? I mean, I can't imagine why. What would be an unusual use of a residential condo?
I mean, it's just your typical short-term rental, investment property, or large dogs. They won't allow Dobermans or pit bulls or, you know, known to be aggressive dogs, or however they phrase it.
One person told me they wanted to open a college student, a studio, use condo for that purpose. Found it difficult to find if there were any objections to it.
Yeah. Yeah.
I have a small question about it's a townhouse, but maybe for condos too. Is it reasonable that HOA can say about the tenants that are going to be inside? For example, 4 students that are sharing the house, the condo. Is it reasonable? Because if an owner can rent a house for tenants, not one, not a family, it's just 4 people. Now, when I'm saying 4 people, it means to have 4 cars.
Right. Yeah, they can. I've seen HOAs do that. It can't be discriminatory, obviously. So they have to be careful if they are doing that. Because I had one HOA. I forget how we worded it. That had that situation. Because they too did not want a frat house, if you will.
Yeah.
And there's also city ordinances that would come into play as far as occupancy for people because of that purpose, because of cars as well. How many cars can be parked out on the street, or how many days or times per year. I mean, there's city ordinances on that, along with HOA documents and regimes. Do you have a question? Oh. Anybody else? Or?
You think you have a sense from the title company perspective, how they look at all this? I think condominiums are a lot of trouble. We ought to start charging more. I can say that in-house. We can't say with our competitors because then we're in bad trouble. So, James?
But I did want to share with the class that you may have some clients who think, well, I'll purchase the property and I'll rent and just not let the HOA know about it. The HOA is constantly, well, typically, or the ones I'm familiar with, constantly searching for any kind of short-term rentals on social media or any other places. If they find it, it's in violation. You're looking at some substantial penalties, so I would encourage, we want to work with buyers and think they can avoid being discovered. That's not a thing to let you,
Well,
please come up in your
let's get to the point Scott made, is talk to your buyer about what they want to do with the property. And if that's what they're looking at doing, you may have to decide whether or not you can really afford to represent them. Because when the dispute hits, it's not just them, they're gonna hit us too. So we'll work through that, but what are the big things from a title company perspective that you see that you guys are facing claims and so forth with for condos?
Condominiums?
Yeah, anything in particular that you have?
Oh,
keep
well,
having?
not keep having, but a deal, usually it's the assessments and understanding who's paying for what. It's on the resale certificate and in that paragraph 12. Those are always a dispute as far as when you're getting, it's a capital reserve, it would have been due anyway, or there's an assessment that was made because there's a casualty loss of one of the common elements that happened, the pool, flooded and it flooded the gym. Right? Well, who's paying for that? Again, it depends what the declaration is, but they like to spread that cost over all the units. Right? And so typically that's going to be on there. Well, I don't want to pay for that. Right? Or you're going to pay for that. So that can become an issue as well, because all assessments that are due need to be paid at closing. And so you see those type of issues come up. So we have a casualty loss too. If somebody has a flood, especially in their condominium, it's going to be a very long process. Because the claim is not always just going to be, well, the HOA is going to deal with it. It could be that all the units are paying for it. Maybe some of the units are, or they do an investigation and figure out you were negligent. So now you're going to have to pay for all the water damage that was done. So
The same thing with lawsuits against the HOA.
Right, lawsuits against the HOA, one mad, owner's mad, or there's a slip and fall. I mean, there's a lot, the more people are living at the property, the more problems you're gonna have that could arise, and could hold up the deal.
So does the HOA not have like, what is that, insurance, like, do they not have like someone falls as an association? Do they have that
insurance?
They do, but that insurance company is gonna take a look at the claim and figure out, well, who else was negligent? Right, where they're insured negligent in upkeeping the property and they deny it.
So paying your HOA fees does not, that insurance does not cover you as an individual, like, you know what I'm saying?
You'd want to get insurance as well for your unit and for things of that nature, personal body harm, property and all that other kind of stuff. And I'm sure there's riders, I'm sure insurance company have riders for that. If it's attached walls and, you put a hammer through it and break their, Picasso painting smash that through it. That ain't good.
Just like with regular single family homes and a mandatory HOA. You'd have your insurance work through that same process. Here you just have additional insurance that the condo owner association has for the property they own.
And you got 500 people.
Yeah.
So.
Nightmare.
Yeah.
Any other final good questions for Scott? We really appreciate him being here.
Yeah.
I did one other question.
No.
Are we gonna see a copy of the presentation?
Yes.
You share it with us?
Yeah, it's here. It's right here. It's only about 3 pages, just some bullet points. Okay, I didn't remember that. Okay, yeah, that's what this is. It's good to keep handy, and then the rest of it contract. So.
And Carla's going to send it out.
Yeah.
Everybody signed.
Oh, no, we're not through. I get to talk.
I get to defend myself. He gets to talk about this. Everything that I said.
I do want to talk about one additional thing real quick. You got a condominium addendum to listing. So if you take a listing that's a condominium. This is an addendum to the listing agreement. Should be on the last page in your packet there. And so this is something that you'll want to deal with your seller. When you take his listing, go through this process and make sure you have this completed. This goes along with your listing agreement. For both the enforcement of the listing agreement and also for the obligations of the seller. You work through this. So I got you this for mostly reference to read through it. If you have a condominium listing, anybody here have a condominium listing? You're about to, or you have?
Next one.
Okay. So
I know, I need.
you do. So that's good. And of course, what was that question there? You got it?
Oh, no, that's fine. I was just looking to see if this was ours or if it's like that. for others.
Just more of a comment talking about the insurance when Colton was up there. So I asked my wife about the reason why the insurance is higher. The gist is just basically when there's damage, it can trickle down from like an upper level down to a lower one.
Sure.
But I really think that maybe we should talk to Suze about getting a class of insurance and condos.
Yeah, I thought we had a series of insurance classes that we were.
Talking about that's Wednesday. I don't know if you're talking about condos specifically.
Max, come here. Come here. So I recall, we've got a series of insurance classes. I remember seeing something like that on the calendar. Remember?
No, I don't remember.
We were just talking about how we probably need an insurance person to come in and address some things.
Well, we had them last week.
That's not even condo.
Do what?
Didn't your wife come in here?
She did, and I don't know exactly what the schedule is for the class that was this month. I'm not going to be here every Wednesday. Wednesday.
Okay, I guess that's what I was thinking about.
But I mean, it kind of sounds like people need to know
Sure.
details.
Oh, yeah. I think for condominiums, understanding the insurance of what the condominium association covers, what their insurance covers and what it doesn't cover. It's like when you've got a duplex and you have roof damage, you and your neighbor your neighbor doesn't have insurance. How do you deal with that?
You talk to me about it and it's complicated. I could have crap goes over my head.
Yeah.
But it's well, efficient though, like you're in for help.
I think it's one of those things that, we advise our clients to talk to an insurance agent because we're not going to give insurance advice, but we're going to be aware that there's something they need to be able to do. Carla, thank you very much for coming and bringing some goodies. We appreciate that. Very well. Any last second questions for any of you? You feel like this was what helped you in the condo stuff, but you learned some good things here? Was it good use of your time? Zoomers, are you good? Any questions from my Zoomers? No, we good? How many are that with?
Thank you. You told.
Very good. Thank you all very much for being here. We appreciate it. And thank all of this office for investing in Tree Pack. We won the contest. We were in a mega agent category. We beat out all the other mega offices. DPR, Fathom, Exit, beat all of them.
Congrats.
Well, for you guys invested, thank you for that.
You're very welcome.
You turn them off now? We're recording off, what I'm talking about now.